Good afternoon and welcome to the Livewire, UNC Charlotte's forum for conversations with newsmakers from here on campus and beyond. I'm Will City. Nearly 5 decades have passed since the Supreme Court famously remarked that students do not shed their constitutional rights at the schoolhouse gate. Our nation's highest court has heard only a handful of students' rights cases since then, but litigation in lower courts has exploded. Each day, school officials struggle to balance the rights of students with the need to maintain a healthy learning environment. The troubling reality for educators is the rules on how to do that are not always clear. Among the most difficult judgment calls schools must make is whether and how extensively to search a student. On today's Livewire, we look at how schools handle the Fourth Amendment. My guest, Dr. Dunaway, has taught law to future teachers for more than a decade. Prior to that, he spent 25 years in K-12 administration, including 3 years as a superintendent. Dr. Dunaway, thanks so much for being here today.
My pleasure.
So as an introduction, I'd like to talk a little bit about the Fourth Amendment in general, and specifically about its application in TLO versus New Jersey, which is the case that has set the baseline for how the Fourth Amendment is applied in schools.
Well, the Fourth Amendment came about after the British had actually invaded citizens' homes. And so the government, the writers of the Constitution, the Bill of Rights, were intent on making sure that people's possessions were protected. And so the Constitution established that law enforcement officials had to have a warrant and had to be sworn before a judge before they could go into a person's house. The case New Jersey versus TLO was a case that came out of a high school. There were 2 girls who were discovered by a teacher with lit cigarettes in their hand in a girl's restroom. Now what's interesting about that is that smoking per se in that high school was okay, so that the possession of cigarettes was okay, but it was against the rules to smoke in the restroom. And so the teacher brought them to the assistant principal, Mr. Choplick, I love that name. And one of the girls admitted that she was smoking, and she was assigned to like a Saturday school, a smoking cessation class. And the other girl, who was just identified as TLO, said no, that she wasn't smoking, and in fact she didn't smoke. The assistant principal asked to see her purse. He searched her purse, found, first of all, a pack of cigarettes. He removed the pack of cigarettes and continued to search, and he found an amount of marijuana. He found a fairly large amount of money, and he found a list of student names with some dollar signs or whatever behind them. And so he suspended the girl, called the police arrested her. She was adjudicated as a delinquent in juvenile court, and she then appealed that verdict based on the fact of what's called the exclusionary rule, that he needed to have had a warrant in order to search, and therefore that evidence should be excluded. The exclusionary rule itself is basically our only protection. I mean, if officials come into our house and search and seize something and do it illegally, if that evidence can be used in court, then we don't have any protection. So she was arguing that particular rule should apply to schools. The case made its way up to the New Jersey Supreme Court and eventually to the U.S. Supreme Court, where the U.S. Supreme Court ruled that, number one, students did have rights in schools. They were really just affirming the Tinker decision earlier, and that the Fourth Amendment applied to students in schools. And then they went further to define how schools ought to know when they have enough suspicion to search.
This articulates the framework that the court came up with for schools to look at before they search a student. If you could just take us through some of this.
They said the search has to be reasonable under all circumstances. So the court is saying, let's look at this thing in total. And you can know it's reasonable, at least the first test of reasonableness is it has to be justified. The court said justified at inception. That means that when the search or before the search began, you had to have enough evidence in order to to justify the search. So what is that amount of evidence? Well, it is some amount of evidence, the courts have said, that's more than a hunch, for instance.
So a teacher couldn't say, you know, this guy, he just kind of looks like a druggie.
No.
And search him. That's out of line.
But if as a teacher or as an assistant principal, I saw behavior, let's say I saw, as that teacher in TLO did, I saw smoke coming out of the bathroom door, then I have enough suspicion to go a step further. That certainly would be enough. That would be reasonable at inception. Then they said the scope of the search has to be reasonably related to the reason for searching.
And this is where a lot of teachers get tripped up,
It
correct?
really is. Scope, a synonym for scope is intrusiveness. I mean, this is dealing with privacy. So how far the search goes, that is, are you asking a young man to empty his pockets, or are you asking him to take his wallet out of his back pocket? Now, for instance, for guys, taking a wallet out of their back pocket may not be particularly intrusive. If you said to a girl, I'm going to search your purse, she's going to see that as a very intrusive act. Now, if, let's say, a student was wearing a coat this day, and you asked them to take that coat off and you were going to search the pockets of that coat, that's a pretty intrusive search. If you then go a step further and search the pockets of their jeans, that's even more intrusive. The most intrusive search, the search with the greatest scope, would be a strip search. And TLO doesn't forbid strip searches. It just says you better have a lot of evidence before you strip search. What I recommend to the students I teach is that first of all, don't ever strip search. Number two, that if you even think about it, you ought to have what would be the equivalent of probable cause. That's a much higher standard. That's a standard of where I can go before an independent magistrate and convince him that what I'm looking for is where it is. And if you have that much evidence, then you need to call the police and they can get the warrant and they can do the search.
And then the other piece that fits in here, we're talking about intrusiveness as in the effect on the student, but the scope is also related to what the violation at issue is, correct?
Absolutely.
So the more severe, the more intrusiveness is allowed.
And you know, the thing that would come to mind at this particular stage would be, for instance, weapons in schools. We hear about that all the time. We've just experienced the shooting in Charleston, and every time we hear about guns in school, we want to know, well, how did that get by? A kid with the potential of having a gun, that's probably a strip search that would be justified almost every time, simply because of my duty as a principal. My first duty is the safety of the kids in my care. Another thing that has to be considered in terms of the scope is the age, the gender of the child. It seems that almost any time that I read where a search has gone awry, a strip search has gone awry, it tends to be with kids who are younger and who are susceptible to school officials just simply telling them to do something and them doing it. The most recent case that went to the Supreme Court was a case called Safford v. Redding, which was a case of a middle school girl who was strip searched because she was accused of having ibuprofen. That's a pretty extensive kind of thing to do, and the emotional trauma that would bring to a 13-year-old girl is pretty significant. It's another case long before that one that the Supreme Court did not hear, called Doe versus Renfro, where the schools brought in dogs and the dogs went up and down the aisles of a school, and a dog alerted to this girl who the court identified as Doe. They strip searched her, eventually took her to the school nurse. She denied ever having any drugs, and the school nurse eventually strip searched her, and as it turned out, she had played with her dog that morning before she came to school, and her dog was in heat. that that anybody would go that far is pretty amazing. But obviously, there are cases out there where it shows that they have gone that far. So if we look at those three things again, it needs to be justified at its inception, have enough evidence before even considering to do the search. It needs to be, the scope, the intrusiveness needs to be related to the violation you expect. So it may be against school rules for a kid to have gum, and I could technically search him for that, but the possession of gum is not like the possession of a gun, and I ought not, and I should not go as far as I would otherwise.
So we've seen here that strip searches usually oftentimes end up being out of line or require a high degree of offense or a high degree of evidence. I'm going to go through with you just some closer calls to show how the court has applied this in the past. And these were some examples cited by the Association for Supervision and Curriculum Development. 4 students huddled together, one with money in his hand and another with a hand in his pocket, does not provide reasonable suspicion. That sound right?
It would have to be more than that. For instance, I can think of a situation that I was involved in personally where there were a group of kids huddled together, but there was, kind of like in TLO, there was smoke coming up from the crowd that was where the kids were huddled together. The smoke would have provided enough suspicion for that to be reasonable, but just the fact that kids huddle together all the time. They have their hands in their pockets. That's not enough.
An anonymous phone call advising an administrator that a student will be bringing drugs to school, coupled with the student's reputation as a drug dealer, creates a reasonable suspicion to search the student's pockets and book bags. So educators are in a better position when they have multiple pieces of evidence from different sources.
Yeah, and you obviously have to be careful with the anonymous call. But if the anonymous call is coupled with the fact that perhaps I had actually caught this kid with contraband before, then those two things give me enough suspicion, for instance, to pull this kid into my office and to begin a search.
And here's another situation where educators or administrators sometimes run into a little bit of trouble. The odor of marijuana in the hall does not provide reasonable suspicion to search all students' book bags, purses, and pockets. What's the problem there?
Well, the problem there is that sweep searches, that is searching everybody, and generally sweep searches are conducted in order to find out if there is any violation. And the court, back at the Fourth Amendment again, says that the evidence has to be specific. I have to be able to know where it is and what it is and who has it, and this constituted a sweep search, which meant that if again, it's like the British government did with American citizens. They would go in and search an entire neighborhood. This says no, the suspicion has to be individualized. And that's one of the things, whether we're talking about school searches or searches on the street, that pretty well has been established. There are a few places the court has said it's okay. For instance, in airports, safety issue. Perhaps concerts or ball games, but again, that's a safety issue where there's but to search a classroom of kids because you think you smell marijuana has gone beyond the line.
Let's switch gears a bit and talk about the theories that underlie the debate on these issues. Originally, prior to the TLO decision, the broad authority that schools were given was based on a theory that they were acting in loco parentis, or basically as temporary parents for these children, and they didn't have the sort of adversarial relationship that police have with criminal suspects. How would you characterize the relationship between teachers, administrators, and their students?
Well, the in loco parentis prior to TLO was a frequently argued defense by schools when searches were brought to court. The schools would say, we were acting in place of the parent. The Supreme Court in TLO said, no, that is not a valid reason to conduct a search. I mean, it's not a reason to conduct a search. Does that mean that schools don't still, in many ways, act in the place of a parent? Yes, we're called to be concerned about kids, to take care of the kids, and it brings up a tough situation for us, I think, when we recognize that we are here to take care of the kids And that very doctrine, I think it's probably the reason the Supreme Court struck it down, gets us in trouble, because we think we're acting as a parent would, and really the students in a school don't have the same Fourth Amendment rights they have outside of school, because the school environment is unique. We got a lot of young, very young kids or adolescents gathered together in a small place, and therefore the court has said that they have Fourth Amendment rights, but those rights are limited. However, they've also said you can't just act willy-nilly in terms of searching someone. You have to have an amount of care. And I think their three-step process that they identified to define reasonable suspicion is a pretty good one.
Let's talk about the other side of the theoretical debate, and that's the people who say that we're teaching young kids to be citizens while they're in school. And if that's the case, we need to keep their constitutional rights as close as what they will be when they become citizens. What's the merit to that argument?
As a principal, I would frequently go into senior government classes when they were teaching about the Constitution and spend 2 or 3 days teaching the kids about the Constitution through the lens of their rights as students. Until you do that, they just see it as an esoteric document. But when you can talk with them about these are the rights that you have in school. Now they will be somewhat different than the rights you'll have when you get out of school. I think the argument is not so much to get it close to the line as to what they will look like when they step out on the street as citizens, but to make sure that they understand that the Constitution and the court is flexible according to the situation. Just like we mentioned, we can do sweep searches in airports. The police cannot do a sweep search in a school in order to find out whether or not one kid, let's go back to that anonymous call. The anonymous call was that a kid, we don't know which one it is, has brought marijuana today and he's in a 7th grade class. Does that justify us then in searching the entire class? No, it doesn't, because the suspicion needs to be individualized. But all of those situations are opportunities to teach kids about what their rights are. What worries me more is when schools and frequently school resource officers and sometimes the police actually carry out what would be a clearly illegal search. What does that teach the students? And those things happen because the people who are supposed to know about the Fourth Amendment and how far it goes in schools have not educated themselves well enough to know how far that they can go and how far they can't go.
And I'm interested specifically in your opinion on the role of school resource officers in educating and in following the rules as far as the Fourth Amendment goes.
I think that's an emerging area of the law, because a school resource officer, if they're dressed in uniform, and that uniform is the uniform of a sheriff's department in Rowan County or Charlotte-Mecklenburg Police Department or Cabarrus County, and they're dressed in a uniform, they, in terms of the Constitution, are a police officer. They're not a school official. And there are situations where they are often treated as school officials, as another arm of the administration's discipline. And so whereas a school administrator could go and search every locker in that school, they don't need any level of suspicion to search a locker because the lockers belong to the school. A police officer could not do that, and yet there are plenty of situations where they're doing it. The case that you talked about a minute ago about emptying the classroom and searching the classroom book bags and things was probably done with a police dog and either a resource officer or a policeman there. That makes it no more legal or than if the school administrators had done it themselves. And
to highlight how this relationship between police and school officials can sometimes go awry, we're going to show a quick clip of something that happened at a school district, and we'll watch the clip, and after you can give us a little background about how this came about. What's the background here?
Well, the background is that there was a pretty significant amount of drugs coming into the school. The principal explained that they were oftentimes coming in with kids who had transferred, and they seemed to be, from the principal's viewpoint, kids were buying drugs, and they were buying them in this one particular hallway. And he engaged the Goose Creek Police Department to come in after school had started, block off that hallway, and what you saw were police officials with guns drawn, putting kids on the floor face down, in some situations cuffing them with zip ties. I've looked at this clip dozens of times. I use it in my class as an illustration as to why school people need to understand where the Fourth Amendment goes, because unfortunately police officials don't always know. And this went awry. And so the last thing you saw was the dog coming through. And so if you take all those things together, the police have blocked off a hall, they have put kids face down on the floor. If a kid responded negatively to them, they handcuffed them. And then they brought a dog in and did a sweep search. That's about as much illegality as you could get in a 30-minute clip, and they paid dearly for it. The police chief lost his job, the principal lost his job, the school system lost, I think, $1.5 million, maybe a little bit more, from students who sued. I mean, you know, I put myself in the place of a parent there and say, how would I feel if my son came home and told me, Mom, this is what, or Dad, this is what went on today at school? I would be irate. I would want to do the same thing. And so that was as good a definition visually of an unreasonable search as you're likely to find. And it was 2003, so this wasn't something prior to TLO, and it was done with it was collaboration between police and school to make it happen, and yet it still went awry.
Now, when you see a clip as shocking as that, it's easy to have a visceral reaction and be angry at the teacher or administrator that may have asked that search to be conducted. But I think we have to also look at how people are being trained. What kind of training are teachers and administrators getting about these kind of issues?
It's a great question. And I can't speak for South Carolina. I can speak for Alabama, where I've been, and I can speak to North Carolina. A required course of all aspiring administrators is a course in school law. That's a 3-hour semester course. That's 15 weeks, about 45 hours. Now, not all of that is devoted to the Fourth Amendment, but a good piece of it is devoted to the Fourth Amendment. So school administrators have had at least that much time. They have looked at the Fourth Amendment. They've probably read TLO. They've probably read some other cases. Perhaps their professor gave them a situation and asked them to judge it, so they should know. Ignorance obviously is not an excuse. Teachers, that's another story. If you went back and looked at that video again, you might see, I know there's a longer version of the clip, you will see some school officials, and they're typically PE teachers, you can tell because they're in shorts and golf shirts, who are around as the police are working. My guess is they had no knowledge of whether or not this was illegal or not. And the reason I say that is because I have not been a participant in or taught in a school of education or known any of the teachers that I've hired through the years who ever had a course in school law. And I think that is a terrible mistake that we make. The kids in school need us to know that we understand their constitutional rights. But teachers are also vulnerable. When I read newspaper accounts where teachers have potentially violated a student's rights, oftentimes it was simply done out of ignorance and not understanding what the law is. And again, that won't mean that teacher will keep their job, but it means that we ought to have enough concern both at the university and as administrators that we're educating our teachers about what can and can't be done in those situations.
In terms of the mechanics of that training process, you've written in the past about the challenge of getting teachers to understand the difference between personal reasoning and legal reasoning.
I call it school teacher logic.
Right.
Yeah, and I talked to him about coming over to the dark side. That's over to the lawyer side of things. But when I still put myself in that category as teacher and principal, we're in the caring business, or else we wouldn't be in schools. It's too hard a job. I mean, there are a lot of jobs that are easier to do than to work with 1,200 kids on a daily basis. And so we need to know what goes on. And teacher logic is logic that says, because I believe or think this, I'm going to act on it. And that can get you in big trouble in court, because the court is going to look at, we looked just a minute ago at the three expectations of the Supreme Court related to the Fourth Amendment in schools. The court's going to ask, did you do this, this, and this? And if you didn't do it and you had ignorance of it, then that's not going to be an excuse. In other words, if you use school teacher logic would go like this. I'm taking up, let's say I'm taking up money for a field trip. And Johnny comes and says, Dr. Dunaway, I brought my $25 for the field trip. I put it on my desk. When I went back to sharpen my pencil and I came back, it was gone. My school teacher logic kicks in and says, somebody in this room has Johnny's $25. And probably the next thing out of my mouth is, nobody's going to leave this classroom until I get that $25.
Because it feels wrong.
Because
somebody did something
Johnny
wrong.
was wrong.
Right.
Somebody did something wrong. And so I'm going to, if I'm not careful, I'm going to find myself going the next step. And that is, okay, I'm going to look at all your book bags. Now, book bags fall in a category of, they belong to the students. But the students have some rights related to whether or not I search that book bag. Now, if the book bag is in a desk or under a desk, I may have a little bit more leeway. But if I go too far, and when I read cases in the newspaper that have gone too far, they almost always start like this one, and they end up in a boys or girls restroom where someone is strip searching the people to see if they have $25 on them. And it all started with good intent. It all started that I care about Johnny and the fact that he lost his $25. But as school teachers and school officials, we need to know, how far can we go? Can we do a sweep search in that class to find the $25? No. I mean, one of the things that I love about teaching school law is that we're constantly looking at decisions, bad decisions usually, that people have made, and looking at them and questioning whether or not I could have made that same decision. And it's a fun course to teach, because people begin to see themselves and say, you know what, I thought about doing that same kind of thing. Or if I ask them, have you ever been in a situation where you were told to, and your students were told to leave their book bags on the floor and come outside and stand in the hall, that we're going to bring the dogs in and do a search? Almost universally, the answer to that is yes. And so yes, they can get that.
And that's about all the time we have for this week's edition of the Live Wire. Tune in next week, same time, same place.